Welcome to Workplace Wake Up, your go-to podcast for practical employment law guidance. I'm Jennifer Shaw, the founder of Shaw Law Group, and I'm here to help HR professionals and leaders navigate the legal minefields of the modern workplace. Each week, we tackle real-world issues with clear advice and a little tough love. Let's get started. We're going to talk about something really interesting today. An LA jury hit Liberty Mutual Insurance Company with a $103 million verdict back in December. And for California employers, this is really a wake-up call. Actually, what's interesting to me is this case really wasn't about a bad email or rogue manager. It's about numbers and patterns and outcomes. Now, what's interesting here is that this case actually went to trial, which we talk a lot about how these cases do not go to trial. Well, this one did, and it did not work out well for the employer. I am happy to report that we have a very special guest today in studio, Joe Beachboard. How are you today, Joe?
I'm great, and thank you so much, Jen, for the invitation. I'm a big Workplace Wake Up fan.
Oh my gosh. Well, Joe, thank you. Well, as many of you, I think, know, I've mentioned Joe a few times on the podcast, and he has been a mentor and just a great friend for so long. So I'm so happy to have him here. And he's got some really interesting perspectives about this case. We're actually going to break down today how statistical evidence from this verdict in the Liberty Mutual case really made such a big difference and the impacts on California employers. But before we get started, Joe, I want to talk about the Employers Lawyer Legal Update that is coming next Wednesday, February 11th. It's a webinar that you and I are both doing. I know we're both super excited about it. We're going to be talking about all of the key laws and developments for 2026 that our California employers need to understand. And really, our focus always, and it's why I really enjoy working with you, is about the practical side, right? What do HR professionals really need to know? So, Joe, what can our listeners expect from the webinar? What are we going to be doing next week?
Well, I think at the end of the day, Jen, we're going to be preparing them for 2026. Basically, we're going to give you all the information that you need regarding what's new, what's changed, and what will probably change in the future. And you're going to get it all in a 1-hour period of time. And the best part of it is you and I are doing it for free.
It's free. Yes, our favorite word. I love it. You know what's so good, Joe, is that it is really bare bones in terms of everything you need to know, how you need to deal with things, and what the next steps are without going through a bunch of legalese and a bunch of, court decisions and developments that are really just for lawyers. So I'm excited to do it. I think it's going to be a lot of fun. I hope all of you will join us. Just go to the employerslawyer.com website and you can register. Okay, so Joe, back to Liberty Mutual. This is such an interesting case. So in this case, we have a woman who sues. Okay, she says, look, I believe I was the victim of age discrimination and retaliation under the Fair Employment and Housing Act. That is our law here in California, where we deal with discrimination and harassment and retaliation. And this verdict is one of the largest age discrimination verdicts in U.S. history. And I think both of us are sort of fascinated by this idea of the role that statistics played in this case and how the numbers really shook out. I think a lot of times HR people like to say, and I say this as a lawyer, I'm a lawyer. I don't do numbers. I don't do math. Well, we better, right? Because that's really what this case is about. So, Joe, what are the basic facts? What happened here?
Well, first of all, Jen, I think it's important for your audience to recognize that this was a trial. And as a trial, we don't have all the details as we might have on a reported court decision. But basically, it appears to be that there was a disagreement over the reason for her termination. She believes that she was terminated as part of an overall strategy by Liberty Mutual to favor younger workers over older workers. Now, she was certainly in a protected category. She was over 40, and she had over 30 years of tenure with Liberty Mutual. So she'd been there a long time. Liberty Mutual, on the other hand, claims that there was an issue with one of the accounts that she handled, specifically with respect to their workers' compensation insurance, and that there was some misrepresentation and perhaps even some dishonesty associated with how she managed this account. And that was the position that they took. Well, as you mentioned, the case came up for summary judgment, and Liberty Mutual actually got summary judgment. The case was reinstated on appeal and went to a jury here in LA County. And I know you're in Sacramento, I'm down here in Los Angeles, and in front of a jury in LA County, when you're a big employer like Liberty, that's not where you want to be.
Mm-mm.
So, after the trial, the jury found in favor of the former employee. They went into the second stage to assess the damages, and they found that she had incurred over $20 million in compensatory related damages, both past and future, and then also found that the company had acted in a malicious fashion and awarded $80 million in punitive damages, which all your readers, I'm sure, know are designed to punish and deter. That's what punitive damages are all about. They're not necessarily associated with the damages that the individual suffered. They're designed to punish that company and deter others from engaging in that behavior. But there's a lot of questions coming out of this case as to how it was handled and how it was documented and how the allegations were investigated. And all of these have many, many lessons for your listeners.
Well, I think that's right. And from the perspective of getting to watch a case from the beginning to the end, we just don't get that chance all the time. We don't get to see what happens. So many of these cases are settled, especially if you have employment practices liability insurance. We know that the carriers usually, I think probably rightfully so, say, look, let's just get into mediation. If there's a problem, it's too expensive to defend these cases. One of the things that's fascinating here to me is Liberty Mutual obviously thought they had a good case. I mean, there were multiple ways to get this case dismissed or resolved, I should say, earlier. It actually got dismissed by a court, right? That's what a summary judgment motion is. The court says, hey, even if everything she says happened, it's not going to create liability. And they get to go. They're done. They did their work. And what a change of fortune, right? You get a court to dismiss this case, and then you get a jury to come back and assess over $100 million. Now, I don't know if that amount is going to hold. I mean, obviously, I'm doubting it. And certainly there'll be appeals, there'll be negotiation to try to get that number. So we're not going to end up with Liberty Mutual paying that amount. But it's still a staggering figure. And I do think there's this whole, maybe this is an issue we talk about another time, Joe, about sort of the mind of a juror, right? And how you come up with that number with somebody who made the amount of money that this plaintiff made. It's very hard to get to $20 million in lost and future wages when she's already worked 30 years in the field. It's just very interesting how they went through and calculated what's going on here. Okay, so I think there's some myths of California employers that we rely on sometimes. Things like, oh, we had neutral criteria for making our decision, or we had a legitimate business reason for what we did, or, oh, HR and legal reviewed what we did, so it must be fine. And this verdict really shows that's not enough all the time, right? In this case, you've got this long-term employee, and the jury just didn't buy the reasons for terminating her. And she was able to come up with evidence, numbers, statistics to show, you know what, the older I get, the less you want me, the less you like me. And she was able to convince the jury of that. I know we weren't at trial and we don't have the inside baseball on this, Joe, but what do you think they did? Like, what did the plaintiffs do? What did her lawyers do that was so successful, do you think, for this jury? Like, what did the jury really put their arms around?
It seems to me, Jen, that it's likely that the plaintiff's counsel took a dual strategy. First of all, they attacked the basis upon which the company asserted was the reason for her separation, this issue associated with this very large account. And they challenged the company's investigation and their conclusion and their ultimate decision that she should be terminated. The second thing that they did is really interesting, and that is to look at the statistics. Yeah. And I think it's fascinating to note that her assertion that, in fact, over the 30 years that she had been there, there were fewer and fewer workers over 40 employed in that group. So she had statistical support for her position that, in fact, as you aged, as you said, the company didn't like you as much as before.
Right.
And having that statistical information, especially, it's cases like this that show this is why you don't want to be in front of a jury, right? And you're right, we could do a whole episode just on the challenges and who juries are and why employers have a real challenge in front of them if they take a case to trial. But in this case, they were able to point to the statistical evidence supporting the underlying position that over time, the company hired and employed fewer older workers. And as a result of that, were able to use that to support their opinion and their assertion that this decision that the company had made was really based on age discrimination and retaliation. Because, Jen, an important fact was she claims that she actually went to the company and said, hey, it looks to me like the older you get, the less likely you are to have more of a career here. And that's an important fact as well. And whether or not they properly investigated that allegation was also a key part of the case.
Right. And she goes on this leave of absence for a medical condition. She comes back and finds, the key card in the garage is deactivated. And she's told, go to HR, and she's let go for this big issue with the client, right? And I was thinking about, pretend I'm their lawyer and they come to me and say, look, we've got this person. She's a long-term employee. We've got this big issue she's created. She's coming back from leave. What should we do? I always tell folks, look, just because somebody's been on leave doesn't mean that you shouldn't hold them accountable, right? But you got to think about what you're doing. And I think when you consider what the jury did, there has to have been some disconnect for those jurors between, they said they had a legitimate business reason, but it just doesn't pass the smell test, right? The jury didn't think so. We obviously don't know what actually happened. And I think it is very important that a court dismissed this case. So obviously there was enough evidence to support what Liberty Mutual was doing at one point in time that a superior court said this case shouldn't go anywhere. This case should be dismissed. So I don't know if they did more discovery after that hearing on the motion for summary judgment or what happened. But here we are with a very large, very significant verdict that lots and lots of people are talking about. And I think it really shows, Joe, the importance of getting behind or underneath the reasons, the rationale that managers and leaders are giving for making decisions. The Supreme Court has this theory called cat's paw, right? Where they want to make sure that the HR folks are not just taking what a manager or supervisor says at face value and terminating someone and being their instrument for discrimination, being their instrument for retaliation. We have to, as HR professionals, take a step back and really question, what's going on? What are the numbers? What actually may have happened here, right? And I'm not saying that didn't happen in Liberty Mutual. I'm sure the HR department did a great job. But the idea of just having someone say, this issue happened with a big client, and therefore it justifies taking a 30-year employee and eliminating her from our workforce, right? Terminating her. You're going to have some evidence. You're going to have something significant. And if I remember correctly, she received a good evaluation, a pretty positive evaluation, not too long before they terminated her. Now, of course, something can happen, right? You get a good evaluation, now you steal $50,000 from the company. That doesn't preclude you as the employer from taking action. But when it's something that's a performance issue and not a misconduct issue, it's not I stole $50,000. It's, I just didn't have the right interaction with this large client. It does make you wonder. And I think that's probably one of the things that the jury was focused on. Now, Joe, employers do training. They have policies. They document what's going on in the workplace. But in this case, it didn't really seem to be enough, right? We don't know what training they actually did. We do know there was a lot of documentation because that's how they won the case before the Superior Court in the first place, right? That's how they got it dismissed. But I think we want to remind everyone that just having these sort of things that you can check a box on, like I did my training, I did documentation, the personnel file looks really nice, I have a good termination checklist that I followed. Okay, great, but pull back the lens. Does it make sense? Is something missing? Does something feel a little unfair? Does it seem like maybe there's something else going on? And it may not have anything to do with the age of this plaintiff, or maybe the numbers showed that there was a reduction in people as they got older because people didn't want to stay. People wanted to go do other jobs. They had other opportunities. Who knows? There's lots of ways to explain numbers. But it's such a good reminder that California juries look at outcomes, right? They don't know what was in your head when you went to make a decision, when you said, okay, I think there's enough here to terminate this person, or I think there's enough here to deny a reasonable accommodation. They look at, well, what happened? We have a 30-year employee who lost her job. You better have a good reason for that, right? Much different than somebody who'd been there for, 6 months. And then you've got these numbers. And of course, many people feel like numbers are numbers, right? Now, we all know numbers can be manipulated, but it's kind of an objective thing to look at, right? How many people over 40 do we have in these jobs? And how does that compare to where we were 5 years ago? So ignoring that kind of data is a gamble. Obviously, huge risk for employers. Joe, do you have just a final thought for employers on this case?
Well, Jen, I think you really hit it there, is that keeping an eye on your demographics, right? I mean, anyone who listens to your podcast has learned a lot from you about how to properly position a termination that is defensible, right? But something like these statistics can give the jury something to hang on, right? To say, hey, look, these numbers are here. And I don't know if Liberty Mutual looked at those numbers or not, but they were persuasive enough that the jury was able to perhaps overlook a well-documented employment performance issue that this employee experienced and say, no, that's a pretext. And what's going to support the pretext decision is the fact that there's been this trend of fewer and fewer older workers. So I think a lot of times HR professionals, they'll think about, we need to look at demographics when we're undergoing a reduction in force or something like that. But you really need to have a good sense of your demographics all the time so that you can properly assess the risk if you're going to be taking action against somebody who is in a protected category in which you have declining members.
That's such a good point. Joe, thank you so much for joining us here today. It was always such a pleasure.
Thank you for the opportunity.
Everybody, thank you so much for joining us today. Go out and have a great day. Don't forget to register for that legal update. We've got the webinar next week. You can go to employerslawyer.com and we will get you all signed up. Thanks, everybody. We'll see you next time. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. Thank you for joining me on this episode of Workplace Wake Up. If you found today's discussion helpful, be sure to subscribe, leave a review, and share the podcast with your HR and leadership teams. For more insights, training programs, and legal updates, you can visit us at shawlawgroup.com.